SJC-11799, Commonwealth v. Michael Walters.
Good morning. Okay, Walters.
I apologize, Your Honor.
That's right. I gotta find out.
Okay, Mr. Stiles, all yours.
Good morning, Chief Justice Gants and Justices. I'm Ethan Stiles, and I represent the defendant in this case, Michael Walters. Mr. Walters has challenged all his convictions today, but I'll be talking about the issue which I think the court is most interested in hearing, especially after the amicus briefs, namely whether the Facebook page constituted a threat, and if so, was it communicated to the victim. So first, I'll start with this Facebook page and photo, and what I call the salad bar threat in this case, because from the Facebook page.
The salad bar threat?
Yes, the salad bar, and I'll explain that reference. Because from the Facebook page, you have to pick any elements that are going to support the so-called threat and ignore the rest, and there are several of them.
Do we know when, in relation to the posting of the photograph on the Facebook page, that the statement appeared on the Facebook page?
We do not, Your Honor. We have evidence that this photo here, which is at page R63, was added on January 13, 2011. But we do not know from the Facebook page itself, where we see here's the thumbnail of the photo, and here is the quote, "Make no mistake, my will to succeed and bring you two idiots to justice."
Where's the thumbnail photo?
I'm sorry,
Is it right below
that's
it?
R64, Judge.
Okay.
So here and here, these two things you have to take, and the rest of the stuff on this page about his education, his work history, his tastes in music and sports, his work habits, you have to ignore all that because those things can't be a threat. But these two things, which we have no idea when they were put together, if they were put together anyway.
You didn't have to be his friend to see any of this stuff. I mean, anybody could get on this Facebook page, right?
Anyone with a Facebook account could get on his Facebook page. However, at that point, in 2011, I believe the statistics show that there were 600 million active Facebook users. But
so 600 million people could have gotten on to see this page.
That's correct. And anyone who could have made it.
He could have, if he only wanted a select group of people to see this, have confined the group who could view that information.
My experience is that.
Yes or no?
Yes, he could have, but that was the default settings at the time were that profiles were public to the Facebook community, and you had to take steps to make your profile.
It's difficult to do.
It requires an active step, but this court has now. I'd like to get back to that when I talk about communication. So first of all, you have to pick the elements from the page which you feel threatening, and then you have to go further if you want to take this two idiots quotes and determine that you are one of those two idiots, and that he really means not justice in the accepted sense of the term, but he really means some kind of personal vengeance. And I would suggest that is too vague, too ambiguous, too vague, too ambiguous, not targeted, and shouldn't be a threat.
Was there any evidence that the victim had a Facebook page herself when the two of them were together? Was social media, that aspect of it, part of their relationship?
No, certainly not by that time. Now, it's important to note that.
No, I'm not talking about that time. I'm talking about during the time that they were together. I'm just trying to figure out whether he had any expectation that if it was a threat, it would be communicated to her. That's one of the things we're looking at.
There was no evidence at the time of the harassing incidents, which covered a period from July of 2007 to June of 2008, 11-month period, that they were Facebook friends or that either of them had a Facebook page. In fact, even in 2011, when this was discovered by her husband, the police officer, they were still unclear whether they had a Facebook page at that time. So I would suggest to you that there was no particular evidence suggesting that they would have that they were Facebook friends, or they would have come across.
I'm sorry, I'm not being clear. I'm trying to find out if Mr. Walters had any information at all about the victim's use of Facebook.
We are aware of none. I'm aware of none that came up during this trial, and I would suggest that that it's my brother's burden to show that Mr. Walters did have some awareness of that they were on Facebook, and that. But all that the evidence was that the husband got a tip from somebody saying that Mr. Walters is going to make another complaint against you because he had made several internal affairs complaints against his police department for pretty much every time their paths crossed. There would be an internal affairs complaint following. That was the pattern. But the husband was never named as a victim in this case in any way, shape, or form. And the other recent context we have at this time, that's what the court should look to, and it has always looked to that in the past, to recent context surrounding the language, if we're going to look and interpret it, is what was Mr. Walters doing at this time? In 2011, not in 2007, 2008, 2.5 years prior to this, but in 2011, he was suing them civilly in Rhode Island. And that's what.
Why must we restrict ourselves only to that if there hasn't been any connection except for the earlier time that might have been significant because of the guns?
Well, I would suggest that if we don't, we have no date on this Facebook on when this quotation here was made. So if we don't do that, the internet can hold material for a long time, and we risk the issues becoming stale.
Now, can I ask you about like other lawsuits and actions? This was not just in 2011 he did this, right? Or
well, in the broader sense, during the time of the complainant and Mr. Walters were fighting about the restraining orders. Now, they had many hearings on those, and you can see that from the restraining order, which is in the record appendix. And he fought with the police department regarding the husband's conduct, and then
that was going on when?
So the restraining orders lasted at least from December 27th, 2007 to I think April 2009. And also...
and the complaints to the police department about the husband?
I think the husband acknowledged a dozen complaints.
What period of time is that?
He's not clear, but I would suggest that at the last one probably would have been around that January 2011 period when he got the tip.
Right, so there's a continuing sort of not being done with each other. Let's put it that way.
They're not, and also I would also point out that that at the district court level he was being prosecuted for these offenses. He makes reference to that at one point.
Actions he took.
Well, I mean, the restraining orders actions that she took, the maternal affairs are actions he took, but all of that is seeking justice or something having to do with legitimate justice.
That may be, but I think that it's certainly it's not like he disappeared from the scene.
No, but
and left them alone
for a 3-year interval.
3 years, so that you can't look at history as somehow a relevant part of the context.
And I don't say to ignore it, but that history does not show any evidence that he's going to be making a true threat, and that's what we have to find here, is that this post...
No, but it does lend meaning, does it not, to the statement about the two idiots?
It does give meaning, but I believe it gives the meaning that this is not anything having to do with vengeance, or that he's going to shoot them. If you look at his photograph, you can see it's just him holding a gun. He has like a half smile on his face. He doesn't have his finger on the trigger. He's not pointing at somebody like in some of the cases. I think the juvenile case was one of them.
Pretty big gun.
It's an M4 carbine. It's a military weapon.
So what about his playing with the guns in the house when he never did that before? I mean, that's part of the context too, isn't it?
Well, I would suggest if there was a continuous pattern from 2007 when that was alleged to have happened, because after, I think it was September 27, 2007, she got the restraining order and he was out of the house. So they were no longer living together after that. So if there was a continuous pattern, 2008, 2009, 2010, 2011, yes, we can look to that. But there is no such pattern in this case, Justice Hines.
Now help me, I probably should know this. Are you challenging the jury instructions in this case?
Well, all the judge said was that a true threat is not a face. The true threat is not protected by the First Amendment. There was some evocation of the First Amendment, but Mr. Walters was handling himself pro se. So I'm not sure. I don't believe that there was a specific motion to eliminate for jury instructions or an objection
So what
thereto.
was the jury instructed as to what a threat is?
Well, it would have been, I believe, if I remember correctly, the jury would have been instructed consistent with the statutory instructions on stalking, whatever those instructions are.
So are you challenging the adequacy of the jury instruction, or is this a question of the sufficiency of the evidence?
I would suggest it's more of a question of the sufficiency of the evidence, Judge and Chief Justice. And I think that the courts, when First Amendment issues are implicated here, as they clearly were, that the courts take a second look, and they looked. And your responsibility is to look and see, is this a true threat because of the values at stake?
Well, if it's sufficiency of the evidence, it's whether or not a jury rationally could so find.
Well, but I believe that the court here has an obligation to take a second look, and it has. But we do start with where the jury has come from. Now, I'd like to turn to communication because I know that was raised by several of the justices' questions. Now, under the theory that appears to be advanced by the Commonwealth and some of the amicus briefs, publication online equals communication. But I would suggest that that's not this court's jurisprudence. That under this court's jurisprudence, we can find that a threat has been communicated if the defendant relays the threat directly, relays the threat to an intermediary with the intent that the intermediary communicated it to him, or relates it in a fashion that it will be reasonably understood that the third party would communicate to the victim. Now, I have held no case where the court has held in this situation that just putting it out there is enough. That's essentially what I call passive communication, and I don't think the court needs to expand its jurisprudence to allow for that sort of thing. Because at that point we get to the issue of the victim who goes looking for threats online. They search the person's all their internet activities, hoping that they can find something. And they can find things that are stale, like I would allege in this case is stale. And they would also, and also if that were the standard, then it may very well affect a prior restraint on the defendant's speech, because at that point, there are people he can't talk about, and that can easily go to places where he can't go to, because you might find something threatening. So if he wants to complain that the domestic violence laws are unfairly enforced, or the sex crimes are unfairly prosecuted, he would have to consider that he's being watched, and therefore I would suggest that would have a prior restraint.
If you had in this case, which is not the case because it was the husband who went on the line, but let's say 15 of the victim's friends, sometime in January after that photo was posted, call her up and say, I'm a Facebook person and I was checking this, and this is what's there. And so it's clearly getting it's obviously getting communicated to some of those 600 million Facebook subscribers, and they are communicating it to her directly. Would that matter?
Well, I would suggest. Well, I mean, we don't have any evidence of that in this
I know.
case.
I'm just asking you whether, because part of what you're saying is you can't take something that's on a sort of passive thing on Facebook and turn it into a threat.
Well, in situations like those, I mean, typically you have friends and friends of a friend who can post and repost this stuff online and otherwise draw attention to a post. But that's not this case, Justice Bosford, and that may be coming up. But in this case, all we have, it's out there, and they didn't even get the tip. Hey, go look on his Facebook page.
No,
You're
I
gonna
know
find
that.
something.
That's why I'm just asking you. If they had, would that make a difference?
Well, I think there was a good case that the ACLU cited. It's called United States versus Jeffries. That's a Sixth Circuit case about the rapper who made a threatening song about the judge. In that case, he actually said, he shared it with other people. He said, "Go tell the judge this." So I think that's a clear case, Justice Bosford, of when communication online, meets the standard. But as far as, I think. I'm not, because when you look at cases where the court has found that there was no communication, I think the appeals court cases, they're called First and James. Those are the murder for hire ones, where someone asks someone else, go kill my wife, and that someone else relates to the wife, he's going to kill you, or the husband. And in those cases, I think the court has implicitly acknowledged that, yes, whenever you utter a threat, there is always some possibility that's going to come out there and become widely noted in a way that you don't want it. But in those circumstances, you look to the intent of the defendant, and that is the key here: the defense of the intent of the defendant, and an objective standard against the victim. Because if the victims start looking for stuff online for threats, then we no longer have an objective standard, but a subjective standard, and that's not what's met.
Can I just ask you quickly before you sit down, do you disagree with the position of the amicus that the same standard should apply to Facebook post or any online communication as you would apply to an oral communication?
I would, that if that is the case of the amicus, I would suggest that it is the, as I understood the amicus brief, that they wanted, that they wanted it out there. If it's out there, it's communication, because you can find it. Whereas I understood our case law to be that the defendant has to take some sort of step to communicate it to him, actively by some human being, or even by, I could even accept that if they are Facebook friends, she could receive these status updates that say, hey, he's posted a new photo, and she sees the photo, and it's a gun. That would probably be sufficient communication. But if I understand your question, Justice Hines, if the amicus brief is saying that if she can find it because she put it out there on the internet.
No. Their position was that you should judge whether it's a threat or not by the same standards as you would if it's an oral statement.
Well,
it's yes or no?
I believe in that sense, yes. I think that is what I'm arguing for, but I believe that some of the amicus briefs are asking this court to extend the law of the Commonwealth beyond what I think what it should be. And I guess if there are no further questions, I'll rest.
Thank you.
Thank you very much.
May it please the Court, David Mark for the Commonwealth. If I may, let me start where my brother began with the Exhibit 28, which is Record 61. And that is...
Before you get there, with regard to Rihanna, it says victim of domestic violence in handwriting. Was that before the jury?
I had the same question, Your Honor. I don't know whether there was a failure of redaction here or not. It's not raised, and I didn't compile the record appendix. It may well be that this is the exhibit. It certainly looks like it, and we had the same concern, but I can't address it beyond that.
Was there anything discussed about the photo of Rihanna in the trial?
Not that I know of. So, yes.
So let's assume for a moment that the photo of him with this gun, I mean, I guess he is a veteran, is his sort of Facebook photo posted on day one, and I don't know, a couple of months later, he's posting all kinds of stuff, his favorite activity, sports teams. He posts favorite quotation, make no mistake of my will to succeed in bringing you two idiots to justice. Do we just sort of go through and select, as counsel said, from the salad bar to determine, to sort of decide what's finally constitutes a threat?
So I'm not sure whether you're asking a kind of hypothetical, not this case, because in fact the evidence is, if you look at Exhibit 30, that this picture was posted on January 13th.
Right, but we don't know when the statement was.
Right.
That's correct. But so it appears that the last thing, the finished painting of the picture was on that day, and the evidence is that it was accessed by Sergeant Norton on the same day.
On what day?
On January 13th?
So this photo is posted on January 13th.
Yes, that's the last piece that I would argue creates the complete picture of this page is
This
a
is
threat.
a photo of him at apparently his house.
No, his mother testified it was the house of a friend. The picture had been taken 3 or 4 years earlier at the house of a
With a
friend.
gun on his lap.
Yes.
Okay, so when was the quotation posted?
There's no evidence to that effect.
So it could have
I would
been-
argue it doesn't matter that there's no evidence to that effect. What I would argue is that once the picture becomes complete, once the threat becomes complete and is delivered, it doesn't matter how long it took to paint the picture, as long as the finished picture is a threat and that ends up getting delivered.
Go ahead.
Would the quote itself be viewed as a true threat?
No, the quote itself is a threat, but it's not a true threat because it's not by itself in isolation a threat of violence. It's not a threat of death or bodily injury.
So it's only the addition of this photograph.
Not only that. That is
what else?
essential, but not only that. I would ask the court to look at the entire page.
Right, I understand that, but I mean, you're saying that when this photograph was added, what you call to be a threat became a true threat.
Yes.
So do we need to look at his intent as of January 13th of 2011?
Yes, but I would also say that in terms of determining that we have a true threat at that moment, you have to look at context as well. So I think there's textual evidence here from the page itself. There's also the history that they have, that the victim and the defendant have.
What about the page other than those two things are you relying on?
Right.
Well, there are two things. I mean, I note the unfortunate fact of there apparently being a failure for action, but apart from the helpful gloss on the picture, Rihanna was probably the world's most famous victim of domestic violence. That was hardly likely to be unknown to at least some members of the jury. In any event, it's a fact it's a well-known fact. Additionally,
But how does I'm lost.
My argument, Your Honor, would be that it's not a Facebook page in the normal sense. It was constructed as a threat. If you look at, there are all these sort of subtle elements here that would be understood by the intended recipient as to enhance the threat, to send a message. One of those is the fact that the defendant's sole musical selection's Rihanna. In the context of this case, that's hardly likely to be a coincidence.
Would it have mattered if the statement had been posted at a time when the defendant and his former girlfriend enjoyed a good relationship?
Yeah, it would matter a lot.
So-
because
but-
that would rob the I'm arguing that context is critical here, and it's the context that establishes who the two idiots are. If the context established quite definitively that the statement couldn't refer to the victim, we'd have a problem here. But that's not the state of the evidence at all. So I wanted to address one other aspect of the page that's significant. The defendant lists his sole employer. We know he has a construction business because it's a big issue in the case. His sole employer is listed as Governor's Task Force on Police Corruption. Now look at the history of Sergeant Norton and the defendant, right? I think March of 2008, there were 5 complaints, internal affairs complaints of misconduct lodged against Sergeant Norton by this defendant. There were 12 by January of 2011. So there's a continuing source of animus here. None of these complaints ever panned out. There was no action taken on any of them, Sergeant Norton testifies. But there's quite strong evidence of a continuing animus. So why is the employer Governor's Task Force on Police Corruption? Is there such a task force? Unlikely. Is this person, if there is such a task force, is this defendant likely to be a member of it? I don't think so. I mean,
was there any evidence at trial about that?
No, but I mean, the
So
context.
how are we supposed to take meaning? How are we supposed to assume that he was not a member?
We don't leave common sense behind in a courtroom.
It's common sense whether or not he was a member of the Governor's Task Force on Police Corruption?
What is the likelihood that a person who has a construction business would list and who is this continuing animus with Sergeant Norton would list this as his sole employer when he has his own business?
And speaking of evidence, was there any evidence about when Rihanna became a victim of domestic
No,
violence?
but this is a well-known.
And do we know?
It's not evidence in
Do
the
we know
case.
that it was before January 13th of 2011? I can't say that I have a particular memory of when that happened.
I do, in fact, but
Okay.
And that doesn't matter either, Your Honor. The answer is, I would ask the court, what I'm asking the court to do is to consider that there is textual and contextual evidence that this page is a faux Facebook page in some sense, that all of it is, or virtually all of it, is directed at sending a message. It's quite sparse about the defendant's life, except for stuff that has sort of meaning or can be understood to have meaning as part of and enhancing this idea of a threat, as it's being directed at the victim and Sergeant Norton.
What proof was there at trial, what evidence was there at trial that would go to the issue of communicating this to the victim?
The evidence at trial is that so it would be that the picture goes up on January 13th, and Sergeant Norton testifies that he received a forwarded email that the defendant was registering a complaint with, I forget which.
No, this goes up as of January 2000.
The Exhibit 30 has, there's a note.
Thing goes up as of that.
I'm not saying the whole page, that someone has clicked on the link to the picture and then taken a screenshot of that, and below that it says added January 13th. The defendant doesn't dispute that. In his own closing, he talks about it, in effect, having gone up at that time. So that doesn't seem to be an issue about when the picture went up. There's nothing, I agree, about when the quotation was added to the page. But as you know, I'm arguing that essentially the picture completed a threat, that he may have, over several months, added these things together. But to address your question, so there are two issues here. One is the likelihood that he would come across it, and the other is whether he did. We know that he did. In fact, Sergeant Norton comes across it virtually immediately and then communicates it to his wife, the victim.
So we would need to find that as of January 13th, 2011, he intended this to be a threat?
You would need to find, I mean, this is a sufficiency argument, so you would need to find that a jury could reasonably conclude beyond a reasonable doubt that as of January 13th, 2011, he intended this to be a threat.
Yes. And that it was reasonably likely that this Facebook threat would be communicated to the victim.
Yes. And you've actually accurately summarized the way this jury was instructed by the trial judge. So yes, those are the essential components, that he intended this as a threat, and that it was reasonably likely that it would be communicated either through an intermediary or in some other manner. The judge, I think, correctly left that open. About the sort of getting back to Justice Lenck's question about communication, I would note that Facebook was at this time, and probably still is, the preeminent social media site in the world with an immense number of users and is quite open. We know that there was no restriction placed on this Facebook page because Sergeant Norton testified that he went immediately to it and this came up.
No evidence as to, following up on Justice Hines' question, no evidence as to whether or not the victim at the time they were together, or if he knew since then that she was a social media user herself.
We knew, well, so no, we knew she was an internet user, I think, because we knew about, she had exposure to the Zillow posts.
Right, or her husband did.
Or her husband. So I'm not actually sure whether she herself was.
The defendant would have known some of this?
He would have known that she'd had that she'd been subjected to the Zillow posts. Yes, absolutely, and they were quite obviously intended for her to harass her. They're part of the pattern of harassment.
Well, that's a different matter, but I take it some of the stuff that was posted on the Zillow post came from emails between her and her husband.
Yes, there was the suggestion that he'd hacked her into the private email account. He boasted of his prowess as in effect as a kind of hacker, and that he'd been able to pull private information up and then post it as a page on the Zillow account, which is actually a real estate site.
Yeah, you wouldn't have to prove, or would you, that the Facebook page itself would be seen by the person who was intended to be threatened. It's just that somebody may have communicated the information on the Facebook page to her.
Under the instructions that the judge gave here, We had to prove that it was reasonably likely. Let me see if I...
The reasonably likely that it would be indirectly communicated to her, or that she would have seen it.
So let me read the instruction. Let's see. This element can be satisfied by proof beyond a reasonable doubt that the defendant consciously intended the threat, but it should be to be conveyed to the victim, directly or indirectly, through a third party or by some other means, and a reasonable belief that the victim, probably would become aware of the threat. Probably would become aware of the threat is the standard there, which I would argue is correct and fair. It doesn't penalize conduct that's intended to be private. The kind of private ranting doesn't become actionable under that standard, which is one of the concerns expressed in the ACLU brief.
Let me ask you, there's a case pending in the United States Supreme Court.
Ilonus. I think it's irrelevant, Your Honor, because it deals with, we already have we've imported a subjective intent requirement into our...
So you think that no matter what happens with that...
I don't think whatever is decided in that case, I don't think it's going to affect what you decide here. I don't think you have to wait for that case. Because... Which I guess it'll be decided soon anyway.
Yeah, it's going to be decided soon, but I just wondered what your thoughts were in terms of its likely impact on us.
I don't, because I think our own statute already requires subjective intent here, I don't think it has an impact. It's certainly an interesting case. It might be indirectly instructive, but I don't think it bears directly on the point here. Certainly not on, as raised by the defendant, when we're talking about sufficiency, the Commonwealth is bound to establish to your satisfaction that the evidence was sufficient on the instructions as given, and the instructions as given have this subjective intent requirement. So we're really not dealing with the Ilonus problem here.
Okay.
Can you deal a little bit with the issue of the Facebook page being done in Rhode Island and the victim being in Rhode Island? The effects issue?
I have to say, I think the effects question is kind of a red herring here.
Well, I mean, I gather January 11th, 13, he was residing in Rhode Island.
It's true. It's true that at the time of the threat, everyone was in Rhode Island, so this is the final act. The threat in this instance is the final act needed to complete the crime of stalking. The pattern of harassment had occurred.
So it doesn't matter where the threat took place. It really doesn't at all.
It doesn't matter as long as it's connected to the pattern. If it weren't connected to the pattern, we'd have a problem. But we'd have a problem anyway because we couldn't make out the crime.
But if everybody was living in Rhode Island at the time, why wasn't this prosecuted in Rhode Island as opposed? Could it have been prosecuted in Montana?
No, but remember that all of the harassing conduct, all of those, not just one, but all of those harassing incidents, and 3 are required, plus the threat, those all occurred in Massachusetts. So the fact that an element of the crime occurred out of state doesn't take it outside the jurisdiction of Massachusetts to prosecute.
You mean as long as
our rule had always been, I beg your pardon, just about.
No, I'm just trying to figure this out. If they had lived in, I guess you would say it wouldn't matter, that if they lived in Montana as of 13, or is that when the indictment was?
January. The indictment came down after January.
Right.
The final the threat is accessed on January 2011.
And you would, okay.
But isn't the inference that he put the finishing touches on the true threat by posting the picture?
Absolutely.
And if that were done in, I mean, isn't it inferable, reasonably inferable, that it was done in Rhode Island and it was intended to be communicated to somebody in Rhode Island?
Absolutely. All of those things are true. But so
what's the connection to Massachusetts? Other than the old conduct.
If the threat were not corrected to the harassment, we wouldn't have stalking. So if this were being prosecuted as a separate crime of a threat, there would be no jurisdiction. I agree. All of the acts that were necessary to complete that threat component occurred out of state. But the Commonwealth's contention had been that that this related to the series of harassing incidents early, and that this completed that as the crime of stalking.
Okay, thank you.
Thank you, Your Honor.